So more importantly, though, Will points out you have a bunch of red states. These red states can easily pass laws in their states requiring that if these companies want to operate within their jurisdiction, they have to do X, Y, and Z, which is really fascinating because in Washington, D.C., political affiliation and source of income are protected human rights. Why is Twitter exempt from human rights law in Washington, D.C.? I don't know. Perhaps it's because there hasn't been a sufficient challenge. Perhaps that's what needs to happen. But Will also brings up an extremely, extremely important, seriously, wow, I did not know this. Let me see if I can find it. There's this case right here, the recently decided Supreme Court case. Packingham v. North Carolina is instructive. He says, in this case, Lester Packingham, a North Carolina resident and registered sex offender, posted to Facebook about an experience in traffic court. North Carolina had a law banning registered offenders from using social media sites. Packingham demonstrates what happens when the governments try to use regulation to try and restrict access to social media sites. The facts of Packingham are pretty simple. The government of North Carolina, for perfectly sensible reasons, passed a law that prohibited convicted sex offenders, from using social media. The Supreme Court, in a unanimous decision, found this speech constraint unconstitutional and used very basic settled law to do so. Simply put, under long-standing First Amendment law, the government cannot restrict your access to the public square. Kennedy explains, by prohibiting sex offenders from using those websites, North Carolina with one broad stroke bars access to what for many are the principal sources for knowing current events, checking ads for employment, speaking and listening in the modern public square, and otherwise exploring the vast realms of human thought and knowledge. In sum, to foreclose access to social media altogether is to prevent the user from engaging in the legitimate exercise of First Amendment rights. So here we have it, a unanimous Supreme Court decision holding that the First Amendment prohibits federal and state governments from restricting your access to social media. This is important because it sets in precedent. The Supreme Court unanimously views that social media is the modern public square. Now we have building blocks. It needs to be protected. The solution, as laid out by Will, is actually really simple. You cannot ban someone for legal speech. However, this doesn't give the government the right to ban anyone. See, this is the problem. Right now we're hearing arguments, as Will actually points out, this one from Tiana Lowe, that she thinks if you give the government the right to regulate these platforms, then Obama gets in, and now he's going to impact conservatives. No. That was the point of this. The government unanimously decided, the Supreme Court, that they don't have the right, the government does not have the right to suppress speech, to restrict access to this platform. What they can do is say to the private companies, you also don't have this right. The important thing we're talking about here is that these civics have not been developed yet. Social media is new. It is a new phenomenon. It has only recently gained so much power that it's become a problem.
Am I the reason you get stoned every week now? Build up integrity, got you texting, emailing me, wanting me to feel with you. Baby, just face reality, move on.
Sometimes it's hard to face reality.